You're driving on the Cross Island Parkway just past the merge for the Northern Boulevard exit when a pickup truck drifts into your lane and clips your rear quarter panel. You pull over, shaken, but okay, figuring this is a simple case. Then the other driver's insurance company gets a look at the police report and one line jumps out at them. It says, "You may have changed lanes right before impact." That single sentence is about to matter more than it ever has because of a new rule for car accident lawsuits in New York that most drivers on Long Island have never even heard of. Starting this year, if a jury decides you were more than half at fault for your own crash, you don't get a reduced check, you get zero. And that's only the first change. Stick with me because the way New York decides who's even allowed to sue after a crash also just flipped. And if you've ever walked away from a fender bender with a bad back or whiplash, this affects you directly. For decades, New York ran on pure comparative negligence. If you got into a crash on the Long Island Expressway and a jury said you were 30% at fault, you still collected 70% of your damages. Even if you were 90% at fault, you still walked away with something. One bad moment behind the wheel almost never cost you your entire claim. That all changed on May 27, 2026. Governor Hochul signed a law that added a brand new section to the CPLR, section 1411B, and it applies specifically to motor vehicle cases. Under the new rule, if a jury finds you were more at fault than the other driver, meaning anything over 50%, you don't collect a reduced amount, you collect nothing. The case is over the moment the jury reaches that finding. No damages get calculated, no settlement leverage, nothing. Think about what that does in a real case. I had a client, let's call him Danny, in almost exactly that scenario, clipped from behind on the Cross Island Parkway. Under the old law, even if the insurance company convinced a jury that he was 40% responsible, he still recovers 60% of his damages. Under the new law, that same insurance company only has to push his fault from 40% to 51%, just 11 points, and Danny walks away with nothing at all. That's not a technicality. That's the entire case. And here's what worries me about this change. Before, an insurance company negotiating a settlement had a ceiling on how hard they fight over fault percentages because even a bad outcome for the claimant still meant a partial recovery. Now, there's a finish line worth fighting for. One clean number, 51%, that turns an entire six-figure claim into $0. I've already started seeing adjusters push harder on fault than I saw before this law passed, arguing points they used to concede without a fight. A driver who merged a bit too early, a driver who was allegedly distracted with nothing but a guess to back it up. Every one of those arguments used to cost the insurance company a percentage point or two off the payout. Now, every one of those arguments is an attempt to clear a finish line worth the entire case. Have you ever had an insurance company argue that you were more at fault than you actually were? Tell me about it in the comments because I promise you're not the only one. Here's why this matters for anyone driving the Southern State, the LIE, the Sunrise Highway, or through a Queens Boulevard intersection. Fault used to be a percentage. Now it's a cliff. The second big change is just as important, and it has nothing to do with fault. Before you could even sue for pain and suffering after a car accident in New York, you have to prove what's called a serious injury under insurance law section 5102. For years, one way to qualify was the 9180 category, showing a non-permanent injury kept you from doing your normal daily activities for at least 90 of the first 180 days right after the crash. A lot of soft tissue cases, bad backs, sprained necks, torn ligaments that never showed up clean on an MRI qualified through that door. As of this year, that category is gone, eliminated completely. To sue in New York for a car accident injury now, you have to fit into one of the categories left standing, which are a fracture, permanent loss of use of a body part, permanent consequential limitation, a significant limitation of use, significant disfigurement, or death. If your injury doesn't fit clearly into one of those boxes, the door that 9180 used to hold open is closed. That means that the case that you used to sue on, that used to have a clear path to court, now has a much smaller one, and insurance companies are already using this to challenge claims earlier and more aggressively than before. Someone gets rear-ended near the Northern State Parkway, their neck hurts for months, but the imaging doesn't show a herniation or a fracture. 6 months ago, that was a real case under 9180. Today, without something that fits one of the categories still on the books, that same person may not clear the threshold to sue at all, no matter how much the injury actually disrupted their life. That's a hard conversation to have with somebody who's genuinely hurting. It doesn't mean every soft tissue case is dead on arrival, but it means the medical documentation from day one matters more than it ever did. There's a third piece to this, and it's the one most people never see coming. New York also added a cap that hits closer to home than people expect, and it catches almost everyone off guard because it's not about the other driver at all. It's about you. If you're hurt in a crash, found to share some of the fault yourself, and at the same time of the crash, you didn't have your own insurance, or you were impaired, or you were committing a felony behind the wheel, the pain and suffering portion of your case gets capped at $100,000. That cap doesn't apply if somebody dies, but short of that, it applies no matter how serious the injury actually is. That one surprises almost everyone I talk to because it flips how you'd expect this to work. People assume a cap like this would target the reckless driver who caused the crash, not the person who got hurt. But if you were driving without your own coverage, or you'd be drinking, and the jury also puts some of the blame on you, this cap lands on top of everything else already working against you. Here's why this matters on Long Island. A lot of people out here drive without realizing their own policy lapsed. If that's you and you're hurt in a crash where you're also found partly at fault, this cap limits what a jury can actually award you for pain and suffering on top of the 51% rule already in play. So here's what all three of these changes add up to. Fault isn't just a factor anymore. It's the whole ballgame. And the evidence you have from the moment of the crash, the dash cam footage, the photos, the witnesses who saw the other car merge without signaling, the police report itself carries more weight in New York than it ever has. I've responded to crashes like this before, back when I worked as an EMT, and the first 10 minutes after a crash are chaos. People are checking on each other, waiting for police, trying to figure out if anyone needs a hospital. Nobody's thinking about Section 1411B in that moment, and they shouldn't be. But that's exactly why the scene evidence gets lost so easily, and exactly why it matters so much more under this new law. If there's any real question about who caused the crash, and there almost always is, the difference between 49% fault and 51% fault can come down to a photo you didn't think to take. Go back to Danny on the Cross Island Parkway. Here's what actually happened in that case. The pickup truck that clipped him had a dash cam of its own, and when we got hold of the traffic camera footage from the Northern Boulevard interchange, it showed that pickup truck drifting a full lane width before contact ever happened. Danny never changed lanes at all. Without that footage, this becomes a swearing contest between two drivers in front of a jury that now has the power to zero out his entire claim if they believe the insurance company's version over his. With it, the case is worth what it's actually worth. That's the reality now. It's not enough to know you weren't at fault. You need to be able to prove it, and prove it convincingly, because the cost of losing that argument just went from a percentage to everything. If you've been in a crash on Long Island or anywhere in New York since the end of May, these are the rules your case is actually being decided under right now, whether your insurance adjuster mentions them to you or not. If you want to see how insurance companies are already using these tactics like this to push a lowball settlement, check out the video where we break down the tricks adjusters use on Long Island drivers. It connects directly to everything I just walked you through. And if you're dealing with a claim right now and something about the fault story feels off, our contact information is in the description. Have you had an adjuster argue fault with you before? Tell me what happened in the comments. I read every one of them.